And for the record, Megan Gilmore on behalf of the petitioner and moving party, namely Jordan Kinney. This matter is before the court on my client's motion for contempt. A final parenting plan was entered in this county on September 30th, 2021 that names my client primary parent and provides father alternating weekend visitation. The court also entered a child support order at the same time, I believe at the end of September of 2021, that requires father to pay $100 in child support. My client first brings this motion for contempt as father refused to return the children as detailed within a declaration and in direct violation of the parenting plan. Father sought a protection order in Clark County alleging that the child had a bruise on his bottom. He claimed this occurred on September 15th, but didn't file the petition for a protection order until October 9th and never addressed the allegation or concern with my client in the interim. He also alleges that he was aware of criminal allegations against my client's husband for over 4 years prior to bringing this petition. Despite the parenting plan being in Cowlitz County, as well as my client and the children residing in Cowlitz County, father sought a protection order in Clark County. Not only did he file the protection order in a different county, but father intentionally failed to include under Section 10 of that petition the fact that we have a final parenting plan and custody order in this county. We believe father intentionally misled the court by failing to disclose that there's an order, and father doubles down on this failure to disclose by then including the criminal allegation or the criminal cause number under Section 10, which alludes to a different county that the children or my client of this action were involved in the criminal case, which is frankly not true and undisputed that my client didn't even know her husband when this criminal allegation occurred. Father request for a protection order was denied the same day that he filed on October 9th, as submitted within the denial order submitted by Judge Lewis. My client exchanged the children on October 13th pursuant to the parenting plan with no knowledge that he had filed anything or there was any sort of allegations whatsoever. Father's trying to claim that my client is some sort of trying to mislead the court, even though she wasn't even before the court. He addresses social media posts and other excuses, claiming that my client continues to be in a relationship, but frankly, that's really irrelevant for the purposes of this motion. And more importantly, my client wasn't even aware that there was some sort of allegation being made to even an attempt to mislead this court. On October 17th, despite being on notice that he had received a denial order that he didn't have any sort of standing to keep these kids, father refused to return the children. Father's own responsive materials indicate text message correspondence where my client saying, "Hey, come to my home, I'll show you that Nicholas isn't there," and he still refused. He then not only refused to exchange the child on Sunday the 17th, but then he didn't take the child to the school the next day, indicating within his own materials he didn't want my client to have access to the child. After retaining me and frankly threatening criminal liability, father finally returned the children on the 17th, the following day. My client explains in the declaration that on the 18th, the next day, father took it upon himself to take her address information that he had supplied to her and contact the school district, asking them to file fraud against her because of the new address. My client is a part of the transitional housing program, and this thankfully didn't impact the child, but ultimately these allegations are only hurting the child, not my client. At a recent visitation, this 5-year-old has expressed frustrations with his father because he's interrogating him to get information about my client's home. By way of update, we were before the Clark County Court on Monday. The court denied both protection orders against my client as well as Mr. Kinney. At this point, we ask the court find contempt because father has acted willfully, intentionally in violation of the court's order. We ask the court considers a substantial award of attorney's fees, as we believe that the refusal to return and frankly the protection order was brought in bad faith. My client has expended about $5,000 at this point to get her kids back, to defend a baseless protection order, and to support a motion for contempt. And we do ask the court to consider entering a subsequent orders that neither parent should involve the children in conflict or disparage the other parent to the children. Looking to support, the orders are clear. He had a $100 obligation. He doesn't deny that he hasn't paid $1 of that since the order was entered over 2 years ago. My client denies ever agreeing to modify that order in any way. Father shows receipts for contributions of expenses over the entirety of this order, totaling $162.47. At this point, we believe that he currently owes basic support of $2,500, as that's 25 months at $100 that he's failed to pay. But if the court would like to credit that to the $162 to him, I have provided that math within our responsive materials. Again, we do ask the court find contempt for both the violation of the parenting plan as well as the child support order and consider substantial fees. Thank you.
Ms. Holder?
Good morning, Your Honor. Nan Holder here representing Mr. Jones. First of all, in order to find Mr. Jones in contempt, there would need to be an act of bad faith, and that is not the case here. As to Ms. Gilmore mentioning the protective order and saying that the protective order was in bad faith, that's not what's in front of the court. It is about Mr. Jones holding on to his children after Ms. Kennaway's husband's protective order was granted. So there are two issues here. The first is the withholding. My client did not withhold the children out of bad faith. It was because he had a reasonable belief that Mr. Kennaway, Miss Jordan Kennaway's husband, was still in the home and that the children were in danger. Mr. Kennaway has a conviction for DV4 and DV2, where he abused his own 2-month-old child. That child suffered fractured ribs, fractured wrist, bruising, linear markings on her neck and back, and he admitted to investigators that he did those things that brought about that harm. We originally intended to file the protective orders in Cowlitz County, and the Cowlitz County Clerk's Office directed us to file in Clark County, and that was because there was not an address on record for Miss Kennaway in Cowlitz County, and the children that were protected lived with their father in Clark County. So the Cowlitz County Clerk's Office saw that the appropriate jurisdiction to file the protective orders were in Clark County, so that was not brought in bad faith and it was not done to mislead the court. Additionally, the case file was mentioned and labeled and listed in client's declarations in those protective order hearings, and so it was not to mislead the court. It was listed. It was not to say that the children in this case were in had nothing to do with that case. It was clearly disclosed and there was no misleading of the court. As far as originally filing, we wanted to file on the October 6th date. Mr. Jones became aware of the criminal conviction after his son came to him in September of this year with bruising and said that it was Mr. Kennaway that caused the bruising. Mr. Jones immediately started looking for an attorney because not only did he want to file protective orders, but he also wanted to possibly modify the parenting plan so that he could retain custody as he was concerned with his children. So we filed on, we wanted to file 10-6. We were directed to file in a different county, so we did. That was Mr. Junk's weekend with the children. So then we ended up filing that following Monday on the 9th. Mother and Mr. Kennaway had custody of the children for that week. So Mr. Junk decided to just not serve them until the 14th because as per Mr. Kennaway's own what he said to investigators was that when he gets frustrated or upset, that's what caused the injuries on the children. So Mr. Junk made a decision not to serve the parties until a few days later so that tensions wouldn't erupt and that he wouldn't have to worry about the safety of his children any more than he already did. Then we ended up serving them on the 14th, and that was Miss Kennaway's denied protective order, but Mr. Kennaway's granted protective order. Mr. Kennaway was served at the address that Miss Kennaway claims that she lives at on her own, and he was served that on a Saturday morning at 10 a.m. Further, there are records from the child's daycare providers that Mr. Kennaway was dropping off the children early in the morning and picking them up late in the afternoon, indicating that he still lived in the home with Miss Kennaway. The social media posts are not irrelevant, despite what Ms. Gilmore might say, because it listed and described Ms. Kennaway said that her husband was Nick Kennaway. And then when she was served with the protective order, she then went back and changed it to remove the word my husband and just say he. So there was enough reasonable belief for my client to lawfully withhold the children because he was extremely concerned that Mr. Kennaway was still living in the home. And Miss Kennaway never told Mr. Junct that the parties were separated until after the protective order was filed and served and was approved for Mr. Kennaway. And then it was very convenient for Miss Kennaway to come back and say, oh, we're not together anymore. Give me the children back. The exchange was done, and Mr. Kennaway did give Mr. Junct did give the children back on October 17th after adequate assurances were made by counsel that Mr. Kennaway was no longer living in the home and that Miss Kennaway was the only person on the lease of the apartment. After that, it was discovered by my client that it's likely the reason that he's not included on the lease is because he's a convicted felon, and that could impact their ability to live there. As far as Mr. Junct going to the school and saying that there's fraud, that's not what happened. Mr. Junct went to the school to get his son's school records because Ms. Kennaway did not provide the parenting plan to the school. Therefore, he could not access the school records of his own child, despite the fact that the parenting plan says they have joint decision making. So he went to the school and he found out that Ms. Kennaway was using her mother's address to put her son in a school district that he did not belong to. And at that point, Mr. Junct said, I'm not sure what's going on here. The wrong address was used. I'm not saying there's fraud happening, but that's kind of what it looks like here. So as far as the child support issue goes, both parties were acting under a misunderstanding that child support was not supposed to begin until this fall. There's a text message, and that is from September 3rd of this year, that Miss Kennaway herself says, I'm guessing part of this is coming up due to the fact child support is supposed to be starting soon, meaning she did not believe it was in place. Mr. Junct has never not been supportive. He has given money. He has even asked, hey, do you need some money for the kids? What's going on? Let me help you. So there was no bad faith here. What is interesting is that this is the first contempt motion that has ever been filed in this parenting plan that has been put in place since 2021. The first contempt that was filed was 4 days after Miss Kennaway and her husband were served with protective orders. This is a retaliatory motion. And my client did not act in bad faith, either on the child support, as both parties were acting under a misunderstanding. And Mr. Junct was extremely worried about letting his child and his children in the home of somebody who has a convicted felon for child abuse. Further, we did go to court this past Monday, and Mr. Kennaway's protective order was denied. We have filed for a revision, as we do believe the commissioner got that one wrong. So we would ask that this contempt motion be denied.
Ms. Gilmore?
Just quickly, Your Honor, I think the timeline really looks to the underlying intent of father. The criminal allegation against my client's husband happened prior to her dating him in 2018. My client started dating him, I believe, around 2019, about 4 years ago. My client provided notice of this ongoing criminal liability of her significant other at that time. Father had no concerns. Then the parties enter an agreed parenting plan in 2021. That parenting plan transitions from father having a 50-50 schedule to having alternating weekends in the fall of this year. Then conveniently, we have the allegation made by father that this child has a bruise to create a nexus between the criminal liability and my client's husband. Again, there is some argument that he didn't know the criminal conviction until after the disclosure of the child. That's not accurate. That's not what was portrayed in the declaration. He was aware of the criminal liability way before that. And we believe that, again, he's using child hearsay alleged statements to create this nexus to support a protection order that was ultimately denied. So we have to look also to the reliance on the orders. That he failed to present sufficient information for a protection order in Clark County. He failed to intentionally disclose the parenting plan. Ms. Holder even acknowledges that he was using the protection order to circumvent the parenting plan. He had no authority to keep the kids. My client was more than forthright that she wasn't living with Mr. Kinney. She literally was willing to drive with him up to Cowlitz County to show her residence. And she explains the fact that they have a child, Mr. Kinney and her have a child in common. He was at the home to discuss visitation at the time he was served. I assured counsel that my client wasn't living with him, and there was still a back and forth about exchanging the child. So we do believe that this failure to exchange was done in bad faith. And on the child support, an order is an order, and he failed to comply with it. And he doesn't deny that. So even if the court's not willing necessarily to find a contempt because some sort of notice issue, I asked the court enter a judgment for the amount owing, because it's amount owing that it was not modified.
All right, well, the legislature has created a process that I think looks to most people like a way to end run parenting plans, and not surprisingly, it gets used for that a lot. But the bottom line is there were pre-existing court orders in this case that covered A, child support, and B, the parenting plan. If Mr. Junt felt that the temporary protection order that was granted was in some way being violated, his recourse is to contact the police. It's not to just take it upon himself to decide that he doesn't have to follow the parenting plan. I'm not going to enter any contempt order as to the child support issue. However, obviously we have a past due amount, and Ms. Kenway is entitled to a judgment for that. I am going to find contempt for withholding the child. I guess the best way I can put it is, having said that, it doesn't seem to me like anybody involved in this comes here with entirely clean hands. I'm going to order attorney's fees of $500. Presentation in a couple of weeks, counsel.
Okay. When are Your Honor on the docket next?
Yeah, 2 weeks would be that's the 23rd. That's the holiday. I've got this calendar every Thursday through the end of the year, so November 30.
That or the 16th. I could probably get an order in short, get it filed and exchanged quickly, but whatever the court would prefer.
Ms. Holder, any preference?
Looking at my calendar now, Your Honor, the 16th would work.
All right, 16th then at 9 o'clock. Thank you.
Just quickly, Your Honor, is the court giving him a credit for that $167 or whatever it was that he paid for
Yes.
undescript expense? Okay, I will adjust that. Thank you.
All right, thank you. Mr. Alton, anything you wish to say in addition to what's in your paperwork?
No, I just I'm hoping we can figure something out, because this continues on. It's happened again this last weekend. I'm sorry, I'm really sick right now. It's happened the last weekend. It's happened 3 weekends in a row now, where she's overtaking her time from me. So I don't have much.
Ms. Keefe, anything you want to say?
Last weekend I told him that we were going to go to the hospital because Landon was coughing and puking up blood. And so we went to the emergency room, and Garrett decided to meet me afterwards. Also the time before that, he agreed to meet me at 5. And then the first time I completely read the parenting plan wrong. And I thought that if Landon wasn't at school, it was drop off at 6, not 9. So I did mess that one up. But I mean, I was taking him to the emergency room for puking up blood. He's been having an ongoing stomach issue that Garrett's neglecting.
Mr. Alton, anything you want to say?
Yeah, he had a bloody nose is why he coughed up blood. We went to the doctors and had a doctor appointment. He's also went to a specialist and had ultrasounds and lab works and blood tests done, and everything's 100% normal.
It wasn't a specialist. It was an ultrasound technician. and he didn't have a bloody nose at my house when he was coughing up blood.
Yeah. This is, I just said this in the last case too. The short and simple answer is you folks have a parenting plan. It specifies what you are to do and what time you're to do it. You've got to follow. End of story. I am going to make a finding of contempt against Ms. Keefe. I'm not going to order any fees at this point in time. Mr. Alton, you need to prepare that order. We'll put this on for November 30th for presentation. And Ms. Keefe, look at the parenting plan carefully. Do what it says.
Okay,
That will be all.
thank you.
Thank you.
Mr. Ellis, as near as I can tell, you don't like the parenting plan that got entered.
No, you and I and Heidi and the gal met to review the guardian ad litem's final report about 2 months ago.
Mm-hmm.
And in that, the supervisors were removed for the 3 littlest children. And at the time, yes.
Go ahead.
At the time, you didn't want to make changes to any of the days or hours, but you did want to give me the unsupervised time with the children. And the end result was that my time with the children was cut in half across the board inadvertently. You suggest that I could submit for a new parenting plan. All I'm doing in this proposal is trying to get back the same hours that I had previously to the removal of the supervisors.
All right. And so now let me finish what I was saying. In order to make a change to the parenting plan, you've got to file a motion to modify. You have to give Miss Ellis notice of that and provide proof that she's been served with that motion, and then a notice of hearing showing when it's going to be on for. So unless and until you do that, there's not much I can do. I understand that the process through the court system, the pleadings that are necessary, is kind of confusing and daunting to somebody who doesn't have experience with it, but I am required to follow those rules. So if you want to change the parenting plan that was entered in October, you've got to file a motion. You've got to support that motion with whatever reasons you think are appropriate. You have to set a hearing, and you've got to give Miss Ellis proof of those things. You understand that?
Okay, I believe I've done all that. So can you help me? I submitted a proposed parenting plan. I'm sorry?
You submitted a proposed parenting plan. There's no motion. There was no notice of hearing. I've got no proof any of it was served. So without a motion to modify the parenting plan, I can't do anything.
All of those were done. The parenting plan, the declaration, the motion was the cover sheet on this. We set the docket. We served both the
Mr. Ellis,
guardian ad litem. Yes.
Ellis, I don't know how else to tell you this. There's no motion that was filed to modify. Absent that, I can't do anything. So that's where we stand. If you want to pursue it, you need to file that motion, serve the motion and a notice of hearing, and then I will happily look at whatever it is you're requesting. That will be all for today.
I have a question really fast,
Yes, ma'am.
because I was gonna ask for a continuance because our GAL couldn't come to this hearing. Should I just cancel that continuance
I'm
then?
not going forward with any motion today, so if there's one filed in the future, I will look at it.
Okay, thank you.
Jesse Ebert and Spencer Ebert. So ma'am, are you receiving any sort of assistance for the children from the state?
The only assistance I'm receiving is EBT food. And the kids are on medical.
Okay. So the one issue that we've got is because of that, the state has to be involved in the child support issue. You need to contact the prosecuting attorney's office, their child support division.
I
And
thought we did that.
Yeah, we already did that.
okay, doesn't look like anybody from the state is present.
I got a letter saying that they weren't gonna represent or anything, but I did do the child support paperwork like they asked. And I brought the letter in. They should have had a copy on file.
Okay, I see something here. Okay, so on the child support order, I'm going to strike the language that says Mr. Ebert's not ordered to pay any child support. I'm checking the box that says public health care coverage because you've enrolled the children in public health care. Understand?
Yeah.
All right, if you'll both raise your right hands, please. Do you swear to tell the truth in this proceeding?
Yes.
And you both signed all these documents, is that right?
Yes.
And you've reviewed and signed these as well, Mr. Ebert?
Yes. I do have a couple questions about the parenting plan though.
What's that?
Now I just want to make sure that nobody can take the kids out of state without permission.
Nobody can move out of the state without permission or without a court order, but it doesn't prevent somebody from, going to Portland.
Oh, no. I get that. I just wanted to make sure.
Okay. That answer your question?
Yes, sir.
And ma'am, let me ask you, let's see, when did you separate?
June
June
20th.
of this year? Okay, and is the marriage irretrievably broken?
Is the what? I'm so sorry. I didn't hear you. What?
Is the marriage over?
Yes.
Okay. And is there any property or debts that you need to split that aren't listed here?
No.
Sir, you were nodding your head. Is there an issue about that?
I'm not 100% sure about the debts and stuff like that. I still am trying to figure everything out with that and that aspect of it.
Okay, if any debts show up that aren't disposed of here, you're both still on the hook for it. You understand that?
Yes.
And if you owe any third-party money, anything we do here today doesn't change the fact that they can chase both of you for that money.
Yeah.
Okay. And is this the parenting plan that you've been following already?
We haven't started following it because it was originally a proposed parenting plan at first. We were told to not start following it until after this hearing.
Okay. And Mr. Ebert, you're in agreement with this parenting plan?
Yeah.
There is one thing I'd like to mention though, Judge.
Yes, ma'am.
So I understand Spencer will be having the kids on the weekend. But I would like to make it known, if it's possible, that he has to establish a residence within 60 to 90 days to have those overnight visits, because he is currently living in his truck.
Is there any problem with that, sir?
A little bit, it's not like, so I get the kids every other weekend. It's not like I can't get a hotel room for the weekend, or I do stay in my truck, but I do go to work. And it's not like I don't have money rolling in or anything like that. A hotel room wouldn't be an issue.
Great.
I am currently looking for a place. Don't get me wrong. I am looking for a place. And yes, currently at the moment, I do stay in my truck.
All right. Well, obviously that's not, a good situation for a 5 and a 4-year-old. So you need a place physically to take the kids. And Ms. Ebert's entitled to know where that is. So make sure she's got that information anytime you are taking the children for your visitation. Understand that?
I wouldn't not tell her where I was going.
All right. Then I will grant the decree. I've signed all the paperwork, and that will be all.
Thank you.
Thank you.